The First Amendment is construed to encompass a right to intimate association that, among other things, prevents government interference with a person's fundamental right to marry. In Vaughn v. Lawrenceburg Power System, we explore how courts distinguish between permissible and impermissible interference when a government acts as an employer. Keith Vaughn and Jennifer Vaughn worked for Lawrenceburg Power System, a municipal utility company. When they got engaged, a supervisor, Ronald Cato, reminded them of Lawrenceburg's policy that if two employees married, then one of them must resign. The policy reflected concern that the inherent loyalty between spouses would hinder workplace discipline. Cato informed Keith and Jennifer that if they merely cohabited, they could both keep their jobs. But the couple objected to Lawrenceburg's policy and married without either resigning. They returned from their honeymoon to find they were both suspended, pending a decision as to who would resign. They decided Jennifer would do so. On Keith's first day back, Cato requested Jennifer's resignation letter, which Keith didn't have, and the pair discussed whether Keith continued to object to Lawrenceburg's policy. The meeting's specifics were disputed, but it concluded with Cato firing Keith. Keith and Jennifer sued Lawrenceburg, alleging, among other things, that Lawrenceburg's policy violated their right to marry. They also claimed that Keith's termination violated the Tennessee Human Rights Act because it was in retaliation for opposing a discriminatory practice. Lawrenceburg removed the suit to federal court and moved for summary judgment. The district court granted summary judgment, prompting the Vaughns to appeal to the Sixth Circuit.